Yep.
All right. Thank you to all of you for your patience as we were working through some technical issues with Zoom. I'm James Thompson from Buybox Experts. Thank you for joining us today for the webinar on how to fight back against counterfeit sellers on Amazon. I'm joined by three panelists I will briefly introduce, and then we'll get into our discussion. I have Chris McCabe, who is a former Amazonian who helps sellers with Amazon protect and save their businesses. Chris's company, E-commerce Chris, was the first company founded by a former Amazonian designed specifically to help suspended marketplace sellers. Chris teaches sellers how to think like Amazon, protect their accounts, and appeal listing restrictions and suspensions. Chris is also heavily versed in the world of counterfeits on Amazon, and I'm delighted to have Chris join us today. We are also joined today by Randy Hetrick, the founder and co-chairman of TRX, one of the world's leading brands in health and fitness. Prior to TRX, Randy spent 14 years as a commando in the U.S. Navy SEALs team with an operational career that culminated as a squadron commander for the SEALs Elite Special Missions Unit. Randy's formal entrepreneurial career began in his garage, transforming the crude invention of necessity he had created in the field into TRX's suspension trainer that we all love, know, and use today. In addition to his role as co-chairman of TRX, Randy is also the investor and advisor to early stage businesses and a speaker to organizations around the world, including leadership and entrepreneur at his alma maters of USC and Stanford. We are also joined today by Rich Goldstein, a U.S. patent attorney who works with Amazon sellers to develop strategies to protect their brands and innovate products, as well as grow their businesses around the topic of IP. Since founding his firm, Rich's company, Goldstein Patent Law, more than 25 years ago, Rich has attained more than 2,000 patents for his clients. Rich is the author of the American Bar Association's Consumer Guide to Obtaining a Patent. Gentlemen, I want to thank you all for joining us today. The topic of counterfeits on Amazon is a very complicated one. Let me start by asking you, Randy. You've been selling your brand TRX on Amazon for many years, and you've seen firsthand how broadly fraudsters can use this low-friction Amazon platform to their advantage. How do you balance the sales opportunity that Amazon presents with the policing costs that you incur as a brand in order to protect your brand on this platform?
Well, first, it's nice to be with you, James. Thanks for having me. Yeah, I've been on Amazon since really Amazon started selling anything other than books, way back in about 2008, as I recall. And back then, there weren't the kinds of problems that there are today, because I think, it was a brave new world where legitimate operators were trying to figure out how to play in that space and how to optimize, the merchandising of our products and understand Amazon's rules. The channel is such a powerhouse, obviously, that it's almost impossible for a brand these days to, not participate in it. I suppose you could, but you'd be foregoing a pretty massive, marketplace. And the way that I kind of look at it, James, at this point, and I'm sure we'll dig in a little deeper, but it's become a piece of business like marketing, right? Like hiring accountants.
Yes.
Like paying insurance. That might be the best metaphor, right? Who likes paying insurance? Nobody. But if you don't pay insurance and you have a catastrophic, outcome of some sort, it is truly catastrophic all the way through the organization. And that's sort of how I view brand protection on Amazon. It's an evolving but critical investment if you want to do business there.
Thank you, Randy. Chris, you used to be a seller performance investigator on Amazon, dealing firsthand with bad characters and their actions impacts on other sellers. What has changed on Amazon over the last 10 years when it comes to Amazon's efforts to protect brands?
Quite a bit. And thanks for having me today, by the way. I like this topic because every successful brand needs to expect that somebody's going to try to counterfeit their items. As obvious as that sounds, they understand much better now than they do 10 years ago, even 5 years ago, how to kind of game the system. They understand how these teams operate. Unfortunately, sometimes they even know how some of the tools, the internal team tools, work and are used. and they exploit those loopholes and they weaponize those to accuse each other of counterfeit. There's a lot of anti-competitive behavior. So that wasn't, if I go back to 2010 when I was working on this stuff every day, that wasn't as much of an issue. There were a few bad actors, fraudsters, sometimes they were really sloppy about how they attacked each other, and we could trace it back and
Right.
discipline the right people. But I mean, the sophistication level and the awareness of the loopholes, the sophisticated strategies used now, unfortunately, it's become something that's difficult for Amazon itself to adapt to and cope with.
When you have so many sellers, so many listings, and so few eyes within Amazon, even with Amazon's own technology, this constant game of cat and mouse. We'll talk more about this in a few minutes, but it really is hard to keep on top of all of the approaches that some of these sophisticated fraudsters come up with. And this really does. The problem is only going to get worse as Amazon becomes more and more of a shopping destination for more and more consumers, more and more brands. Rich, I started working at Amazon about 13 years ago, and we rarely had discussions about protecting intellectual property because Amazon saw itself merely as a sales channel rather than a place where all sorts of characters would congregate to make honest and dishonest opportunities around making money. How do you see intellectual property playing into brands' efforts today to build a meaningful asset on the Amazon channel?
Great question, James, and thanks for having me here. So first of all, I think that the path toward having effective IP protection, having an effective IP asset, is similar to the path to succeeding these days on Amazon, which is that you want to focus on differentiation. So a lot of times people come out with Me Too products, and Me Too products have a lot of challenges these days in terms of fighting against other products and having to spend money on pay-per-click to be able to get sales, really. So essentially, the strategy these days by most successful sellers is to focus on differentiation. And then the way IP plays into that is that you then want to protect the differentiation. You want to protect what's different. So if you're differentiating based upon a brand, then you want to protect that brand. If you're differentiating based on product features, you have a feature which truly is unique, then you might be able to patent those features and obtain that asset, which then backs up your competitive advantage on Amazon.
So Randy, you do have patents. You do have all sorts of trademark set up at this point. Talk us through a little bit about how competitors are still able to violate your patents and use Amazon systems to file complaints about you selling counterfeit products of your own. Talk to us a little bit about the kinds of things that you've had to deal with and how you've approached this process of trying to protect that IP that you've so carefully invested in.
Yeah, well, we fortunately, one of the early decisions I made, which early on was a dubious one, to spend all this money, right, to shore up the unique, innovative elements of my invention with IP. And back in the day, right, design patents, IP lawyers would dismiss them as, it's a waste of time because you just work around them.
All right.
And that was true enough in the old world. But in the new world, right, it turns out to be the one thing that most of the online platforms, including Amazon, will enforce because it's easier to enforce. A design patent's like a picture, more like a picture, and less like an intricate mechanical engineer's schematic, and then with that overlaying a bunch of legal language that has to be interpreted. So Amazon's taken the position in the past that, hey, we're not a court. We don't have, I'm one of the only fools that you'll probably ever meet who has litigated all the way to the mat. Maybe not the lawyers on the call, but very few people go all the way through litigation with intellectual property. Generally, it settles, and I know why. Because the one, utility patent and trademark case that we pursued to the mat took 3 years and about $2.5 million. And that is just not something that most brands can endure.
Yes.
And so the bad guys prey on two things. One, they prey on what really began, to James, to your point, Amazon created this unbelievable frictionless marketplace, right? And I think if Amazon's to be, indicted for one thing, it's probably the naivete of not having realized that there's a bad element of human nature that's going to take a frictionless environment and try to bend it to their will. So, that's the reality. And the challenges are twofold. One, the expense, right, of getting and prosecuting intellectual property. That's one of the things the bad guys prey on. They know that most vendors just can't afford what I just described.
Mm-hmm.
And two, they know that Amazon is a much bigger jungle than is actually populated with humans. In other words, it is a technology-based jungle that, the humans who can exercise judgment are few and far between in the jungle relative to the number of vendors, the number of ASINs, and all of the technology. So they prey on that. And the challenge really is that even with great intellectual property, and we've built a multi-layered cake of protections, starting with trademarks, going through utility patents, design patents, trade dress, and copyrights. But the bad guys don't care. They just copy, they keep changing the data that allows Amazon to identify them, and they keep opening new stores. And so what they do is it's a war of attrition, right? And we can get into, some of the ways that we've more or less successfully battled, that war as we go on with our conversation.
So Randy, you still, with all this protection, you still face situations where you will get a customer complaint that you're selling counterfeit, and Amazon will take down your listing for a period of time. And you're having to fight the fight to say, hang on a minute, I am the brand, I have all this patent protection, and yet I'm being falsely accused of selling something that is in fact not what I'm selling. How do you factor these products becoming available, falling out of availability, because quite frankly, there's this noise that you're having to deal with? How do you deal with that?
Well, I mean, one of the ways we deal with it is we employ a really great agency to help us monitor, right, these ASINs, because when you have a broad set of products on Amazon, it's difficult to monitor them all in real time, and particularly on big days, which there's a lot of big days now on Amazon. But
yes.
In the past, to Chris's point, the bad guys will come in, they understand, they learn. I mean, these are not a bunch of dimwits, as I think a lot of folks wrongly assume, that you've got some clumsy guy that's running a sweatshop factory over in China, and he's the guy that's the strategist. I mean, that's not the case. They are running factory direct stores on Amazon, and they've got very smart, very digitally savvy people working for them. So they learn. Everything Amazon does, it's like chess, right? Can be viewed as both a protection and an opportunity if you're a bad guy, right? Because there's a way to game that system. So yeah, they've been, they file takedown notices against the rights owners, and because it's an automated process,
Yes,
often what happens is the brand gets taken down. You then have to go back through the legitimate, ways to redress a problem, and by the time you get to a human, they then go, oh, so sorry, we'll fix it. But you may have lost 3 days during a peak holiday season, right, for that SKU. And meanwhile, the bad guy's product was up and selling, and that's sort of how they view their side of the equation, right? It's just hook or crook.
So Chris and Rich, you both are familiar with Section 230 that Amazon has as a form of protection from the federal government. Talk me through what Amazon could be doing differently in order to vet whether it's vet more of the legitimate sellers or vet more of the illegitimate sellers. How do you put protections in place on either side, protecting the guys that have done the hard work and making sure they don't get unfairly taken down, versus making sure that the bad guys don't get any traction with some of these processes that Amazon already has in place?
Who goes first?
Go ahead, Chris.
All right. So a couple of things. Brand registry needs to get back to its mission statement in terms of helping brands protect themselves against baseless, groundless claims. Often brand registry morphs into generic language teams that just sort of create a ticket for you and copy and paste some standard language in there that doesn't really help you resolve a situation or even help you find out how long it'll take for you to deal with somebody selling a counterfeit version of your product, or somebody who's abusing your brand in the multitude of ways that are available to the fraudsters now.
Mm-hmm.
So brand registry, and then also the notice claim of infringement teams. They didn't have brand registry at all back when I was there, but I mean, we worked on the notice claims in a more competent, responsible way than you see these days. You get a lot of generic answers, and the first step I think that Amazon has to take is to understand, like Randy was saying, there are savvy people out there exploiting these loopholes who understand the system and how to game it. So that means Amazon needs to up their game on how they process incoming IP claims instead of just, well, here's the ASIN, here's the complaint ID. You guys talk to each other and figure out what's real and what's fake. I think Amazon needs to step in and assist a little bit more.
Rich, what's your take on this?
Yeah, I totally agree with Chris. I mean, first of all, I haven't seen any direct application of Section 230 on these situations. And I mean, mostly I've worked with sellers who've had a listing shut down. They're looking for an effective path to get it reinstated. They're not looking to litigate against Amazon. They're not looking to change the world, so to speak, about how Amazon deals with complaints. They just want to get themselves reinstated. And as Chris notes, it's kind of like there need to be better procedures, better standards. I'd say more clear standards. It's nearly impossible to get any guidance from Amazon as to what they're looking for, how they're even considering IP disputes. And I think it's been pretty haphazard. It's been pretty inconsistent. They've made steps towards creating procedures, but then they still don't provide universal access to them, like the neutral evaluation procedure that they created for utility applications. It's not available to everyone. And there are some significant problems with it. But something like that is a step in the right direction, in the sense that it's it's doing something other than having some employee in a foreign call center, or who knows how they handle it, to adjudicate your listing, which could be costing you, 5 figures a day by having it be shut down unfairly.
I think Randy can talk to the cost of a takedown, an unfair takedown. I mean, as you mentioned, Randy, if the takedown happens during a critical time of the year, you could lose hundreds of thousands of dollars of sales in a matter of a couple of days. Can you tell us a little bit more about what actual litigation or co-litigation with Amazon looks like? You've been down that path. When you're actually having to do the lawsuit, the long, expensive lawsuit, how could you see that process? Based on what you know now, how could you see that process working for smaller sellers who don't necessarily have the stomach to be able to deal with that kind of time frame to getting a problem resolved?
Well, I mean, I want to give, I've got some criticism of Amazon, some of their policies, but I also want to give them credit for some of the stuff that they are doing. And in our case, I think we've gotten a lot of attention, in part because we've been on the platform for so long, and we were one of these kind of unusual brands that got counterfeited massively.
Right.
About 5 years in, 5 years into our presence, as we really started to achieve some visibility out in the marketplace, we started to be very aggressively targeted. I mean, like on the level of Louis Vuitton and Rolex and Gucci.
Oh, you're flattering to you, I'm sure.
It was bewildering to me. It might be a better way to put it. I couldn't figure out. I was like, look, we can barely sell these damn straps at this point. Who wants to copy us, right? But the reality is we were hitting an inflection point, and the bad guys figured it out and they came piling in. And so Amazon has done a lot of work trying to help us. In fact, I think we are probably the singular inspiration for the neutral patent evaluation process, because it got high visibility. We ended up winning the largest award in the state of IP award in the state of California in 2017. Of course, the bad guys just defaulted, right? So it's not like you collect anything.
All right.
But that watching that process, really, you couldn't watch it without thinking, this is ridiculous, right? We're forcing this little company to spend an enormous amount of their revenue, frankly, over a 3-year period to adjudicate a patent, a utility patent, which then they bring to Amazon and will enforce. But that's not a reasonable policy. And so, so they put in place a new policy of this neutral patent evaluation. And Rich may be better equipped to talk about how it's working for other clients. We're yet to use it, but I think, we may soon. The other thing that they did is they brought suit on our behalf against a counterfeit ring. And so we were co-complainants in a successful suit, successful because, most of the defendants just no-showed, right? It was default judgment. And then the couple that did show ended up settling because they were so obviously in the wrong. And, that was a very good show of support, I think, from Amazon. So on one hand, you've got very good earnest will going on the side of Amazon. I do think they realize they have a big problem they have to solve. It's just the scale of the problem is so massive that how do you put the genie back in the bottle?
Rich, give us some thoughts on the neutral patent evaluation process. What have you seen some of your clients be able to use this for, and how has Amazon changed their thinking around this process since they launched it?
Well, I would say that the biggest benefit of the evaluation process is it actually gets someone who knows something about IP to look at disputes, as opposed to it being someone who's looking at IP disputes one day and then the next day they're dealing with some other like listing hijacking issues. And so now you get an independent patent professional to review whether someone is infringing the patent or not. The problem is, in the real world, like outside of the Amazon world, one of the biggest issues that most patents should rightfully face is validity. Like, you might be infringing, but the patent's not valid. But you can't raise that in the neutral evaluation process.
So give us an example of what you're talking about.
Well, when a patent is when someone applies for a patent, it gets reviewed by an examiner, and basically the examiner decides if the inventor's definition of what this patent is going to cover, whether that is reasonable, or whether it might be describing things that already exist. Maybe some things from 10 years ago, 20 years ago, 100 years ago. And if it is describing things that already exist somewhere in the prior art, somewhere in the past, then it's not valid. Now, examiners at the patent office have limited time to make this determination. So what ends up happening is people get patents that are too broad. They cover too much territory. They should not be that broad, and therefore they're invalid. But now you have someone who knows their patent is invalid. They know that it's covering too much territory, that they don't really have a patent on the foam roller. What they invented is a foam roller made out of a certain material with a certain type of opening in the ends, et cetera, et cetera. But they have a patent that seems to technically cover the foam roller. And so they're able to enforce that patent on Amazon. If they went through the neutral evaluation process and said, let's say my client knew that there was a patent from 30 years ago for the foam roller, or there was a Sears catalog from 1922 that showed the foam roller, that would be something to invalidate the patent in court.
Yes.
But in the court of Amazon, in the neutral evaluation process, you can't raise that. I have to say that the neutral evaluation process only pertains to utility patents. when it comes to design patents, they can't use that program. And I have fought a bunch of design patent reinstatements on behalf of clients through Amazon. And I would say 100% of the time, the grounds we won on was making that invalidity argument, showing that, okay, both things are, coffee carafes. And yes, my clients looks very close to this other coffee carafe. And yes, they have a design patent. And if you look at the pictures, it looks very similar until you look at coffee carafes from 20 years ago. And then you say, you know what? My clients actually looks closer to the ones from 20 years ago than it does to the one that was the subject of the patent. And therefore, either this patent's invalid or we can't be infringing it. And I've won 100% of the time when I've been able to make those arguments. Now, curiously, I mean, and that's in front of Amazon officials. Curiously, in the neutral evaluation process, where you have an actual patent professional, a patent attorney, who's acting as the arbitrator, acting as the judge, I can't make that argument.
So let's shift gears here for a minute. Chris, I want to bring you in here to talk about competitors filing false IP claims. What should brands be prepared to do when they live in a world where sophisticated folks may play some of these IP claims games? What should you be prepared as a seller or a brand to do when it comes to time delays, potential cost to solve the problem, potentially bringing in other people? Take us through that set of issues.
Right. I mean, have a strategy before you even start dealing with it. Ideally, be prepared, assemble your, dream team of experts, whether it's your attorneys, make sure your attorneys are IP knowledgeable, IP experts, not just attorneys, general business attorneys, but also somebody that understands the ins and outs of how Amazon processes your appeal if you get false IP claims or you get attacked.
So Randy spent all this money up front.
Yeah.
With patents and IP protection. When you talk to small startup brands today, what do you suggest they do? I mean, how much is enough to get started on Amazon versus potentially exposing yourself to problems down the way when your brand gets much more traction?
Yeah, I mean, most of the conversations don't revolve around the entire cost of end-to-end litigation. Smaller brands that are just starting out should at least have a contact who's a reliable IP attorney that they can get this stuff set up with to make sure it's set up properly for starters. That doesn't necessarily cost a lot. If you're already paying, not just, for an attorney, if you're paying the monthly fee for an account manager, maybe that wouldn't be a smaller brand. But if you have any relationship, I mean, also use the resources at your disposal that, like Randy was saying, Amazon does make available to you sometimes to help you out. They're not always, hands off. They do have account managers. I mean, get those people involved. If you have a relationship with category managers through your account manager or on your own, get those people involved in resolving these things faster. If you need somebody to create an internal escalation because the ticket you created with brand registry or the escalation through brand registry or through any other channel isn't going anywhere, it's stuck, and when you follow up, you get generic answers. Right. Understand how to pull those levers. And, obviously, if you don't understand how internal teams work, I'm always around to help you understand that for strategy. But it's good to bake that strategy into your budget and into your planning before you get to the point where you're selling the stuff like hotcakes and then somebody takes an interest in you and decides to try to copy you.
It used to be the case on Amazon. You could go in, you could look at the best sellers in any category. And I think back to 7-8 years ago, if your brand made it to the top 100 list in a particular category, you could assume you had a big fat target on your back, and people would figure out either how to make a private label version of your product, right, or potentially an IP violating copy of your product. Take us through how things have changed with regards to access to data and being able to synthesize all sorts of sales data within Amazon to be able to find not necessarily a top 100 best-selling product, but still one that's big enough that's worth going after.
I think anything that sells well is a possible target. It used to be just the bigger stuff that sold really well, and that's not the world that we live in anymore. The people who are copying things, the people who are aware that you have trouble controlling your distribution or an inability to prove that somebody else is counterfeiting your product using Amazon's tools and systems, those people are performing at a high level at trying to benefit from everything you've created and built. So anything that sells remotely well, you should have a strategy put in place before it starts selling well, ideally.
Yeah.
If you start seeing people jumping on your listings instead of just opening tickets with seller support or pursuing these paths with a lot of waiting, a lot of downtime, and not a lot of work on Amazon's side, understand how to escalate these things early and quickly, knowing that there's going to even be some time built into it for an escalation to go through, as opposed to just, spinning your wheels or looking at seller forums posts or, I know there's a lot of generic content out there from people who say they understand these processes, but make sure you vet them for their real knowledge and you assess that before you even get to the stage that somebody's trying to copy your product, because by then it can be kind of too late.
Rich and Randy, I want to ask you both a question about getting Chinese trademarks, Chinese patents, U.S. custom protection. Given that so much of this product is coming out of China, whether it's authentic source product from Chinese manufacturers or it's counterfeit product also coming out of China, how do you think about IP protection in China? And how do you think about what customs in the U.S. can do to help prevent IP violating products from entering this country?
Well, Rich, I'll take a stab first, and then you can weigh in as the lawyer.
Sounds good.
We have we've extended almost all of our intellectual property into China, and I think that our experience has been that it's occasionally useful if we want to do a factory takedown, but those really are so much work, and they take so long, and by the time you get it done, it's a very porous intelligence system over there, to say the least.
Yeah.
So, other than occasionally as a symbolic sort of gesture, which I think is valuable if you have the resources, the Chinese IP up until this point has played a secondary role. I think that customs, we spent a lot of time educating customs, and customs was very responsive at counterfeit. But the rub, James, is that most of these guys, again, are sophisticated. And so, most of them that we were dealing with pivoted. Most of the counterfeiters, they figured out that, hey, customs will seize counterfeit.
Yep.
Amazon is pretty aggressive in my experience at enforcing counterfeit once you bring it to their attention. So what the bad guys did is they pivoted to becoming knockoffs, which the distinction there is, they're copying all your patents and your innovations, but they're not slapping your trademark on it. And that was a smart pivot on the bad guys' side, because it suddenly made enforcement much more complicated. Customs is looking at it, and they can't adjudicate, patents. They've got an officer that's just looking for counterfeits. The system at Amazon was designed to maybe enforce against counterfeit, but certainly not against nuanced patent claims. And so the knockoff guys all preyed on that. They realized it. They realized, we'll get rid of them. I mean, it's really funny. We started enforcing against counterfeits, and what happened was these guys pulled back, cut off the labels, and for a period of time they were selling then they took the counterfeit materials, dropped it into a plain white box, and then came on the attack again, and the stuff started getting through. And it was like, and we would do a test buy, and we would actually find the thing that had the label cut off of it. Wow. And so that makes for a pretty challenging enforcement environment at all levels, customs, Amazon, and as the brand owner.
Rich, additional thoughts on this with regards to Chinese IP?
Absolutely. First of all, the reason why Chinese trademarks, Chinese patents, Chinese IP can be a secondary strategy, as Randy is noting, is that U.S. patent prevents anyone from making, using, or selling the product in the U.S. So if your concern is it could be made in China and then sold here, your U.S. patent can technically be used to stop them once they bring the product into the U.S., or it can be seized at the border. You can register your patents, you can register your trademarks with customs, and theoretically they would seize the product at the border. In actuality, as Randy points out, they're much better at picking out counterfeiters, which is where they're copying your trademarks, where they're actually trying to pass off the product as TRX brand resistance bands, for example, as opposed to just selling resistance bands that embody all of the features that may be patented, but they're branded differently.
Mm-hmm.
So with that background in mind, sometimes it's useful to have Chinese trademarks, Chinese patents. It's an interesting misconception about Chinese patents is that, well, as a foreigner, you can't enforce them. You can't, if you go to court in China, you will lose because you're a foreigner. And it's actually not true. There's a study that was done of thousands of patent infringement suits, and it turns out that foreigners had foreigner plaintiffs, people bringing a lawsuit, had a slightly higher success rate than even Chinese companies. So, but you do have to be a certain scale for Chinese patents to even be important to consider. Because once again, remember, the US patent gives you the leverage against making, using, or selling, and therefore that leverage is what will keep it out of major retailers, for example. Having the US patent. So sometimes it's useful, but yeah.
Let's move beyond China then. If I plan to sell my product in Europe, I plan to sell my product in Canada, Mexico, how should I be thinking about building IP protections for my product up front or at some point down the road? How do I need to think about all this upfront IP protection?
Okay, great. So let's get technical and then we can get practical there for a moment. So patents are territorial. Patents and trademarks are territorial, meaning that if you want protection in the US, a US patent will do, but in Brazil, you'll need a Brazilian patent or Brazilian trademark to get protection there. So that theoretically means you'd need to get patents and trademarks all across the world. But that would be prohibitively expensive, especially for a company at an early stage. And so you need to be strategic about it. And especially you want to look at where you think that there would be a market for the product.
Yeah.
Again, if a Chinese patent is only important if you're worried about there being a huge market in China to sell your products. So you have to be strategic. And the practical side, again, is that you want to consider that the US patent will give you leverage. I mean, it's like if you have a innovative product, you get a US patent, it's possible for people to copy it and sell it in Europe, sell it in China. But if you have a truly innovative product, for someone, most of the time people are concerned about bigger manufacturers coming along and copying them.
Yes.
For that manufacturer to do it, they would need to avoid the US market. Now, what makes more sense? Counterfeiting a product, copying a product, being able to sell it in some other countries, but never being able to sell it in the US, or working out a royalty arrangement with the inventor, with the patent holder. So, that's the other side of it, is that the US patent typically gives you leverage in those situations. And ultimately, if you really want a worldwide protection, you have to pay for it. It's expensive. So you got to weigh those two.
Randy, you're selling your product in lots of other countries outside the US. How have you thought about the process of getting IP protection as you're entering countries, in advance of getting into those countries? How do you think about that?
Well, we've done it both ways. I think early on, we really had a lot more IP protection than was smart for a company of our size. I had a patent, an IP lawyer who actually wasn't a patent lawyer, but who was big on filing everywhere. And, we upgraded our representation and we got to a more sophisticated firm. They were like, geez, why do you have, patents in the most obscure markets on earth? Yeah. And it really was dumb. But there are a couple of us different groupings, right? The Pacific Trade Conference, European Union, so you can apply for a patent with these large groups that provide coverage in Europe and in the United States and Canada. And so it's a couple of different ways to approach it. And Rich can certainly talk at greater depth, but I think that that's an efficient way to do it. There are a lot of countries that, you are better off having their local jurisdiction patent as well. But I think that the good advice is starting with the markets in which you see volume, right? Likely volume.
Mm-hmm.
And, if you can cover them with a membership in one of the unions of patents, then that's a really efficient way to do it. And if you can't, and you still think that market is important, then go ahead and apply for the local IP. But the maintenance fees are not trivial either. As you start to extend, we were spending really millions of dollars a year on our IP portfolio, the combination of, prosecution, enforcement, and maintenance.
Yes.
And so we've let some of those smaller niche country pieces of IP lapse because they're covered by a larger association patent, and that's kind of how we've approached it.
So going back to the issue of counterfeits being sold on your product, I would think that there is inherently a potential liability that falls back on you, Randy, as a brand owner, having a consumer in some market actually buy a counterfeit product, potentially get injured by the counterfeit, and turn to your company as somehow responsible for this counterfeit. How do you think about this process of going out actively looking for counterfeits, not just because you don't want to see somebody making money on counterfeits, but you want to reduce the possibility of liability from being sued by consumers who end up acquiring a counterfeit?
Well, it's really a combination. Obviously, we want to protect our customer and our brand first and foremost, but you also have to protect no one would ever innovate if there was no intellectual property, right? It doesn't make sense. You spend a ton of time, money, and energy creating a great product, building demand for it, educating the marketplace, only to have some late coming opportunist
Yes.
go, oh, I can copy that and I'll put it, and so I want to get at the heart of the problem, in my view, which is like the one really loud criticism that I have of Amazon, is the idea that you allow someone to buy for a few pennies or a quarter, buy someone else's trademark, right? And then when a customer is searching for that trademark, you allow a competitor to buy placement on that search is insanity to me. And it doesn't exist anywhere else in the universe outside of online. And I'm convinced it's because case law just travels more slowly than the speed of the internet. But I think it will eventually become, it'll be litigated or it'll be legislated, one of the two, because that creates the fundamental problem. When an opportunist can bid on, let's say, my trademark,
Yep.
which we've spent tens of millions of dollars out there in the marketplace trying to educate, create a brand that's trusted, because brands are really about trust more than anything else. And then some untrustworthy guy who has a product that's downright dangerous, to your point. We've actually had deaths occur in parts of the world from people having a counterfeit that broke, fall down, hit their head on the ground, right, and die. And so then what happens? The chain of liability, runs first to the gym, and the case that I'm referring to, was in Germany, and it was a gym owner that had a trainer come in with a counterfeit that he'd purchased off of, we don't know where, we never figured out where. Fortunately for us, we have unique serial numbers on every single product that we make. So that's our liability protection. We immediately say, no problem, we have insurance, just read us the unique identifier, and there's one per strap, and once it's registered, it's taken out of the registration.
Yep.
So that's how we've protected, because the liability is massive. But even set that aside, can you imagine the brand damage that happens when a customer thinks they're buying an authentic product, and they're buying it from a trusted source like Amazon, and then they find out after the fact that they in fact bought a counterfeit that injured them. And I'm convinced that that's one of the reasons why we had success with Amazon as a partner, because Amazon realized, and if you want to get Amazon's attention, they really do, I believe, care about their customer. And so when they saw this as, wow, wait a minute, that's a real risk, we have to put some energy on it. Then that's when we started getting some support, because it is dangerous with some products
Mhm.
when you have, an untrustworthy manufacturer knocking it off.
And
Chris,
that's one of the
Yeah.
fundamental purposes of trademark law, by the way, is to protect consumer expectations. That when they're buying a branded product, that they know that it's coming from a certain source.
Yep.
I mean, we often think about it as being for the manufacturer to prevent someone from cutting into their profit or from cutting into their market share. But it's very much also about protecting the consumer expectations that they're getting the real thing when they buy it.
Chris, we only have a couple minutes left. I want to ask
Yeah.
you, Chris, that given what you see Amazon doing today, if I were a brand getting started on Amazon, where would you suggest I put my time and effort around protecting my brand so that I can minimize the amount of slogging through, false claims that I could potentially get as my product becomes more successful?
Yeah, I mean, and one thing I'd like to say, feeding off the last point, is that unfortunately Amazon cares a lot about preventing counterfeits, but they often have a lot of difficulty deciphering what's counterfeit and what isn't until after the fact, until after an item's already sold and buyers complain, hey, this is fake, hey, this hurt me, this injured me, made me feel not so good, whatever. Not a lot of that work is front loaded because they can't open every box, scrutinize every item,
Mm-hmm.
which, like Randy was saying, it's a massive task. So go into any strategy you build understanding that sometimes you will be a brand owner making your own products and you'll be accused of counterfeiting your own stuff simply because Amazon's building in layers of automation and training of investigative teams lags a little bit behind what might be necessary in today's world, to the point where a lot of times they're unable to tell if it's a fake claim of counterfeit or a genuine claim of counterfeit. So I just wanted to throw that in from the last part. In terms of going forward, I want people to understand that communication is everything when it comes to resolving these types of issues with these teams. There's lots of emphasis and sellers kind of thinking the wrong way, going down the wrong path. Where do I send this? I wrote something up that explains what's going on, fake IP claims, or which sellers are counterfeiting my product, jumping on my listings. Where do I send it? Where do I send it? There's tons of emphasis on where you send things. There's very little emphasis on what you're actually writing and what's sent. Because when people get really worked up and passionate, as they should be, this is their brand, their baby, probably something they've been building for years. There's a lot of emotion that goes into it. Unfortunately, extraneous content doesn't communicate well with Amazon, doesn't travel well in most communication that sellers write up. So I want people to understand that part of your strategy needs to be enhancing your communication so that you can do it succinctly, directly, concisely, and not just using buzzwords or templates, but crafting it in a way that Amazon will understand they need to do something about the complaint you're making or the claim you're appealing.
Mm-hmm.
They need to understand it, but it's a two-way street. They need to do what what you're asking them to do. You need to hold up your end, which is communicate well, clearly, understand if you're not an attorney with that background, then have one nearby who understands the law and who can educate you on the law if you're the one who's writing the appeal,
Right.
as opposed to the attorney. So
I want to open up the question and answers to our attendees today. Any questions for our panelists that we can tackle in the next few minutes? Please feel free to submit a chat or a question on the Q&A tab at the bottom of the page. As we're waiting for questions to come in, Chris, tell me a little bit about your thoughts on Amazon's transparency program. This is a recently launched anti-counterfeiting program. What have you seen work or not work well with this particular approach?
I mean, in some ways it works great because I hear from resellers who say, hey, I got busted for not using transparency codes, which means that's, it's being effective. I'm also hearing from the brands themselves saying it's expensive. They don't necessarily want to make the investment. A lot of sellers still don't know about the transparency program, which could be a failing on their side, not to stay up to date on trends, but also maybe Amazon needs to educate and communicate it a little bit better. And also, it's not necessarily the easiest thing to implement or execute. We've heard sellers complaining we have to label all our inventory, not just the inventory destined for Amazon. And they don't necessarily want to do that for a variety of reasons. So it doesn't fix all distribution channel problems, right? Sellers, whether you use transparency or not, still need to control distribution. You can't go to Amazon and complain to them and ask them to enforce exclusivity for you simply because you don't have tight control over who's acquiring your product and reselling it on Amazon and who doesn't. So
we have a question that came in, Randy, for you regarding Project Zero, Amazon's Project Zero program. Any experience with Project Zero getting counterfeits removed by Amazon?
You know, I should probably know more about Project Zero than I do. I at this point, you know, thankfully, I'm a little further from the flame than I used to be. I think that Project Zero is a fairly new thing, and
yes.
One of the other guys can talk to it for a minute, and then I can tell you, you know, if that triggers something in my memory bank. But I think we've basically been, you know, we've worked through an account rep, and we've, you know, done pretty much everything except we are still in the process of deploying transparency. I think that's going to be useful as well. Mm-hmm. But I can't really speak to Project Zero.
Randy, or excuse me, Rich or Chris, experience with Project Zero and what that does for helping brands to take down counterfeits?
Yeah, Chris, do you? Because I haven't really been involved in that at all.
Well, I mean, so Project Zero again is something that I think sellers probably need to learn a little bit more about. There was a blog post by Dharmesh Mehta, who's in charge of Project Zero. He's the public face of it, I guess, for Amazon, and he's spoken publicly about it quite a bit. We read that article, I think it was about a year ago, and said, okay, well, now that this has been written and a lot of people understand this is important and they understand Amazon's seriousness around enforcement, everyone's going to know about Project Zero. We haven't heard a lot about it being consistently referenced and understood. And I wonder if that's an education issue. Initially, it was launched to fanfare because we thought this would make counterfeit reporting easier and more effective. But in the last 12 months, we've just seen lots of counterfeit allegations being made. There are some valid ones, there are some invalid ones. We haven't seen enforcement teams change how they execute their processes around establishing validity or not. They seem to sort of shift the burden either to another Amazon team or to the complainants and sellers themselves to say, you figure out who's selling.
Work it out together. Yeah.
So
we have time for one more question. I think this is probably a question. I'll start with you, Randy. In your experience, what are the best ways to remove knockoffs from Amazon? So companies that are violating your patent but putting it under a different brand name.
Yeah, I mean, I think the best protective mechanism these days remains design patents, because it's the one thing that, you know, you have to think about what a knockoff's trying to do, right? If we could get rid of the ability for unscrupulous vendors to buy the trademarks of established brands, you would undercut the entire incentive, right, uh-huh. for them to bring products, because they're not interested in spending money to build their own brand. They're not interested in doing their own innovations. What they're interested in doing is copying something that exists, paying a little bit of money for a brand's to be associated with the brand's goodwill in the marketplace, yep. And then they sell a cheaper knocked off product. And so, but you know, the number one way to prevent it would be disassociating their ability to free ride on a brand's goodwill and trust in the marketplace. The second way would be design patents, because the knockoffs usually will try to make their product look as much like the brands as possible to exact copy if they can get away with it. That's something that a design patent's useful, you know, in enforcing. And then I would say that, you know, beyond that, you really have to kind of saddle up and try the neutral patent evaluation process if you have a utility patent. I can't comment on its efficacy yet, but I believe it's, you know, it's earnest will. I think that Amazon has attempted to provide, yep. vendors a better way than federal court in a 3-year, massively expensive process to prove that your patent, is enforceable. And to Rich's point earlier, I don't think that, I suspect that the cases that he was talking about are the tail ends of the distribution, where you have ostensibly legitimate vendors that are arguing about, their IP. I think where the stuff that I've seen mostly is not that. It's not other legitimate vendors. It is illegitimate vendors offshore trying to copy to the stitch, right, what we're bringing to market, make it the same color, and confuse by our trademarks, right, and then confuse the customer. And so that's kind of that's the most insidious, knockoff. It's not honest vendors with disagreements, mostly in my experience. And I can't comment for everybody, but that's been my experience.
We are at our end of our time for today's discussion. I want to thank Randy and Rich and Chris for joining us on today's discussion. Thank you all of the attendees for joining today. Appreciate your time. If you have any questions, feel free to follow up with us at BuyBox Experts, and we'll do our darndest to get your questions answered. Thank you, gentlemen, for your time today, and goodbye to all.
Thanks, guys.
Thanks, James.
Bye, James.